Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Each month, I'll provide an update on the latest developments that matter to you, and we'll be joined by an expert to take a deep dive into a key corporate law topic. Hi everyone! So this month I thought I'd give you a heads up on some potential changes that are coming down the line, particularly for employee ownership trusts and then also some listed companies, or in particular those that maybe are looking to float on AIM. And then I've got one case for you, a quick summary about a case involving the Company Names Tribunal. So first up, I mentioned employee ownership trusts or EOTs. So as I say, that there's been a consultation here on particularly changes to the taxation of EOTs by HMRC, with an aim really to ensure that use of the structure remains focused on the original policy objectives, which were encouraging employee ownership, rewarding employees, because in particular the government's concerned that the structure, that EOT structure, is being used outside of those purposes and in particular to gain a tax advantage on a company sale. So just to explain, what is an EOT, an employee ownership trust? Well, it's a type of employee benefit trust which offers employees indirect ownership of shares in their employing organisation. So the purpose of an EOT is to hold a controlling interest in a company for the long-term benefit of that company's employees as a whole. And over the years, there have been various studies that have shown that greater employee engagement and commitment results as a result of employees having a stake in their company, which in turn leads to those companies being more resilient, adding more staff, generally being more profitable and being able to withstand sort of economic shocks, if you like. So, according to the Employee Ownership Association, who have a terrific website if you're interested in this, and in particular if your organisation is thinking about moving towards employee ownership, but they say that there are now over 1,400 employee owned businesses in the UK. And in the year to June 2023, the top 50 employee owned businesses generated over £23 billion of sales and employed over 181,000 people. The kind of go to example that everybody uses is John Lewis. So that's the sort of ownership structure that we're talking about. So, in order to encourage greater employee ownership across UK businesses, back in 2014, the government introduced various tax advantages for businesses that moved to an EOT structure. So, one of the key ones related to capital gains tax, and in particular, there's full CGT relief for the selling shareholders on the sale of a controlling interest to an EOT. So if you own shares in a business and those shares are sold, enough of them to be a controlling interest anyway, are sold to an EOT, then there's no capital gains tax at all on that disposal. There's also an income tax advantage. So an EOT owned company can pay each of its employees an income tax free bonus of up to £3,600 a year. And then finally, there are some inheritance tax charges. So there's no inheritance tax charge on the transfer of shares to an EOT. And in fact, the EOT itself is exempt from the IHT relevant property regime. So like I say, the concern for the government here is that those tax advantages, in particular the tax advantages of selling to an EOT, mean that the structure is being used to facilitate a tax-free realisation of value for company owners, but without any genuine increase in employee engagement. So, one of the key proposals in this consultation by HMRC is aimed at preventing a former owner from retaining control of the company via the EOT Trust Board. So, after the sale, the company is owned by a trust which is uh, governed by its trustees. And so the new proposals would require that more than half of those EOT trustees are people other than the former owner or people connected to them. So there's a drive there to ensure that there is a genuine change of ownership. Um, the government has also been concerned that the strict rules that relate to the tax-free bonus that I mentioned are making it difficult for companies to actually award those bonuses in practice. So, like I say, there are various requirements that you have to meet in order for those bonuses to qualify as being tax free. In particular, there's what's called the participation requirement, and that prevents bonuses being paid where the proportion of directors to employees in an individual company in a group exceeds a ratio of 2 to 5. So if you've got, say, as part of your group, maybe you've got a small company that could be overseas even, where you've got a higher number of directors compared with employees, then you could be falling foul of that participation requirement just by that in that one little company. But that can then have a knock-on effect and prevent the rest of the group from meeting this requirement. And then there's another requirement which I'll call the office holder requirement, and that requires non-executive directors as employees to be entitled to receive a bonus. And often, actually, that sort of class of employees as non-executive directors, usually you wouldn't expect them to receive this kind of a bonus. So, again, to resolve those issues in the consultation, the government's proposing amending the rules so that tax free bonuses can be awarded without directors also having to be included, and therefore you falling foul of those two requirements. Then also to ensure that EOTs are not used to avoid capital gains tax on any subsequent sale of the EOT owned company. So the sort of current owners sell to an EOT, and then down the line, that EOT is selling on to somebody else. Um, the consultation is going to include or is suggesting that there's a requirement that the trustees of an EOT have to be UK resident as a single body of persons. So you can't have an offshore EOT, if you like. So that is going to require that either the trustees of the EOT are all UK resident, or the trustees could be a mix of UK resident and non-UK resident, provided the former owner was UK resident at the date the shares were disposed of to the EOT. And then finally, just to give a bit of clarification, so there's currently a bit of uncertainty really over the tax status of payments that are made by an EOT owned company to the EOT trustees to repay the former owners for the acquisition cost of the company shares. So when the former owners sell to the EOT, the obligation there is on the EOT to pay the consideration for those shares, but the EOT doesn't have any money. The only way it can get money is by the company which it acquires making payments to the trustees, who then use that money to pay the former owners. So routinely, HMRC does give clearance to confirm that those payments are not taxable, but there are concerns that they could be treated as dividends. So the payments from the EOT owned company up to the trustees, could they be treated as dividends? So, in order to just give a bit of clarity there, the consultation includes proposals to confirm that those payments won't actually be treated as dividends at all. So, as I say, EOTs have become really the main form of employee ownership in the UK, And according to the Employee Ownership Association that I mentioned, there were 332 new EOTs created in 2022, which was an increase of 37% on the previous year. But clearly, there are concerns maybe that the structure's being abused just in order to gain that tax advantage in circumstances which really fall outside the original intended purpose of an EOT. Um, so these reforms are clearly aimed at addressing that misuse, but I think also they will bring us a bit of clarity and also some flexibility to certain aspects of the EOT model, particularly as I say in relation to the payment of those tax-free bonuses, which is a key driver, particularly for the employees there. So the consultation closed at the end of September, and we're going to just have to wait and see which of the proposals are taken forward. But I think it seems likely, probably most of them will be. Okay, so that's one change that we've got coming down the line relating to employee ownership trusts. The other one that I thought I'd mention relates to government proposals for an overhaul of the UK prospectus regime. And I'm going to concentrate in particular when I'm talking about this because this is quite a big topic, but I'm going to concentrate today on how those proposals might affect AIM, the AIM market, and other multilateral trading facilities. So the AIM market is a type of multilateral trading facility, or MTF. So back in 2021, we had Lord Hill's UK listing review. And since then, the government's been consulting on changes to the legislative framework for listed companies and, in particular, the prospectus regime. So the objectives behind the reform include encouraging more retail participation in securities offers, simplifying the regulation of prospectuses, but at the same time not losing or not lowering regulatory standards, and then also, in particular, improving the quality of information that investors receive under the prospectus regime when they're making a decision whether or not to invest in a particular company. So earlier this year in July, the government published a pretty much near final version of some new regulations that are going to set out this new prospectus regime once the current UK prospectus regulation, which is an EU imported and retained piece of legislation, has been repealed. So um, the new regulations themselves are really potentially pretty far reaching, but much of the detail behind that regime has been delegated to the FCA. So the FCA needs to consult on and then implement new rules to bring the reforms into effect. And as part of that process, the FCA has published a whole series of engagement papers that give us a pretty good indication of how the FCA intends to use its powers in relation to the various different aspects of the regime. So, um, as I say, concentrating and thinking about how the regime is going to affect AIM and companies on AIM or companies looking to move to AIM. So, under the current regime, there's no offer. If there's no offer to the public, then a prospectus isn't required for the admission of securities to a non-regulated market such as AIM or another similar MTF, multilateral trading facility. Admission of securities to AIM is governed and regulated by the AIM rules. And an AIM admission document, which is what the company has to issue when it wants to be admitted to AIM, that isn't reviewed at all at the moment by the FCA. And although it is similar to a prospectus, it has different standards of liability, and some of the specific content that's required to be included in a prospectus is carved out of the admission document. So, in a key change to the regime here, the new regulations are going to give the FCA enhanced rule-making responsibilities to decide whether a prospectus is required whenever an issuer is admitting securities to trading on a regulated market, so like the main market, or on a primary MTF, and that's going to include AIM. So rather than regulating admissions directly, the FCA will have the power to require the relevant primary MTF to include certain provisions in their own rules. And these could include requiring an issuer to publish a prospectus in certain circumstances. So, what the FCA is going to do is say to um, uh, AIM or the other relevant regulator, right, we want you to include these particular requirements in your own rules. So, in the AIM rules for companies or the other rules governing a different MTF. So, in the summer, in July, the FCA published a paper setting out how it intends to use its prospectus requirement powers in relation to MTFs such as AIM. And it's proposing that all primary MTFs that allow retail participation should amend their rules to require what they're calling an MTF admission prospectus to be published either when an initial admission to trading is being made or when a reverse takeover is being made, and that reverse takeover involves the admission to trading of newly issued securities. So, under this approach, then an MTF admission prospectus would be the only type of admission document for all new admissions to trading on in scope primary MTFs. Now, crucially, the FCA doesn't expect there to be any material change really in the steps involved in compiling and validating the information disclosed in an MTF admission prospectus. Specific content requirements will be set by the MTF operator, as will the process for reviewing and approving the documents. And the FCA is not going to be responsible for reviewing those admission prospectuses. So, like I say, content requirements for those new MTF admission prospectuses are going to be set by the primary MTF itself, but they will be subject to the same liability regime as currently exists for FCA approved prospectuses. So, what that means is that the people that are responsible for the document, so that's the issuer, the company, and its directors, they are going to be liable to pay compensation to investors who've suffered a loss as a result of untrue or misleading statements or omissions in that MTF admission prospectus. And that, I think, is a pretty significant departure from the current regime. So the FCA is not intending to require an MTA admission prospectus for secondary issues of securities already trading on the primary MTF, but it is considering the circumstances in which a supplementary MTF admission prospectus might be required, and also when withdrawal rights would be exercisable. So, what does this mean? Well, I think probably the introduction of an MTF admission prospectus is going to be welcomed by companies that are wanting to make a retail offer on AIM or another MTF. And the ability to include retail investors without the need for an FCA approved prospectus will, I think, be an attractive option and perhaps will help increase retail participation in IPOs on AIM. Obviously, I think less attractive to the directors of AIM companies is going to be the increased liability that they will have for MTF admission prospectuses. And I think Nomad's nominated advisors are going to be well advised to assess the relevant changes to the regime very carefully to start thinking about what additional risks and responsibilities might be implied and how that might impact the IPO process for AIM companies. In terms of timing, what are we seeing here for when the changes are going to come into force? Well, it's still a little way off, really. I think the FCA has said that it intends to work on developing specific rule proposals following completion of its engagement process, and then it's going to consult on those rules next year during 2024. So I think probably as a result, the new regime is unlikely, I think, to be fully effective before probably the end of next year, 2024, or even possibly into quarter one of 2025. Okay, so that's stuff on changes that are coming down the line. The final thing that I thought I would mention is just a recent case that was in the High Court, where the High Court confirmed the approach that it's going to take when considering appeals from the Company Names Tribunal. So what is the Company Names Tribunal then? What does that do? Well, it deals with complaints that relate to a registered company's name, but only in a very specific set of circumstances. So basically, an applicant, somebody can complain, raise an objection with the Company Names Tribunal if they have goodwill or reputation in a name, and that name is identical or very similar to the registered company name that the applicant is contesting. So the tribunal will consider a name to be sufficiently similar if it thinks its use in the UK would be likely to mislead by suggesting a connection between the registered company and the applicant. So basically, you spot that somebody has registered a company with a name in which you already have reputation or goodwill, a name that you've been trading under for a long time, then you can object to the Company Names Tribunal. So the tribunal has already stressed the importance of the applicant having goodwill in the registered name. And also, crucially, they need to suspect that the name has been registered to extract money from the applicant or to prevent the applicant from registering the name themselves. So it's kind of like an opportunistic registration by somebody of a similar name. The tribunal won't deal with cases where a person feels that another company registration is too similar to their own company name, but actually there's no suspected opportunism behind the registration. You'd need to take other proceedings and deal with that differently. So there are a few statutory defences that are available to the registered name holder, including that the company name was adopted in good faith, that the interests of the applicant were not adversely affected by the registration to any significant effect. If the tribunal upholds the complaint, so you complain to the tribunal because somebody has, like I say, registered a name that's similar to a name that you use, then if the tribunal agrees and says yes, that's right, then it will order that company that's registered with the similar name to change its name. But even if the tribunal makes that order, the decision of that tribunal can be appealed to the High Court. And that was what happened in this case. So, in this case, the company that appealed the decision of the names of the tribunal was called AXA Wholesale Trading Limited. And it was appealing an earlier decision of the tribunal that required AXA Wholesale Trading to change its name. And the tribunal had ordered the change of name because the French insurance and financial services group AXA had made an application. So AXA operates worldwide insurance and financial services businesses, and it has a substantial reputation in the UK. So when AXA made that application to the tribunal agreed with AXA's complaint that AXA Wholesale Trading Limited was a name sufficiently similar to AXA's and that its use in the UK would be likely to mislead people by effectively suggesting a connection between those two companies. So, uh, AXA Wholesale Trading Limited is ordered by the tribunal to change its name, but they don't like that decision, so they appeal that decision to the High Court. But then the High Court dismisses the appeal by AXA Wholesale Trading, and says that basically, when considering an appeal, it's going to adopt the same approach that it does on appeals from the trademark registration decisions of the UK Intellectual Property Office, the Intellectual Property Office, because it says, well, that's the appropriate approach because the legal exercise being undertaken by the Intellectual Property Office and the tribunal were very similar. So, using that approach, the court confirmed that an appeal against a decision of the tribunal is going to be allowed where there was an error of law, but If the tribunal's made its decision based on an assessment of different sources of evidence and other factors, the court's going to be very reluctant to interfere unless it's clear that the tribunal's made a distinct and material error of principle. But in this case, it said, well, actually, the tribunal had correctly found that AXA did indeed have goodwill in the registered name, and that AXA Wholesale Trading had not made out any of the statutory defences of registration in good faith or lack of significant adverse effect on AXA's interests. So, as a result, their appeal failed. So, filing an objection with the tribunal can be a very effective way, actually, of stopping a company from using a registered name. But an application can be quite a costly and time consuming process. And as the tribunal pointed out in this case, actually, if an application is made to it in error, then the applicant's not going to receive a refund. Most importantly, the applicant must have demonstrable goodwill or reputation in the name at the time that it's adopted by the registration holder. And if no defence is filed, which actually apparently is quite commonly the case, then the applicant's complaint is going to be successful. So, although there are statutory defences that I mentioned that the registered holder can rely on, they're not going to be available if the applicant can show that the main purpose of registering the company name was to obtain money or to prevent the applicant from registering the name. So I think this case is useful. It confirms how the court's going to approach appeals of the tribunal decisions. Appeals are relatively rare, actually, but I think it might help prevent pointless and costly appeals being made where it's pretty clear that actually the tribunal hasn't made any material error. So, if the tribunal reaches its decision based on the factual evidence presented to it and by correctly applying the law to those facts, then I think the lesson that we can take away here is that the chances of a successful appeal to the High Court really are pretty remote. So, I hope you found that interesting, and I will speak to you again next month. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.